Leslie Gannon, and I'm an investigator with the Compliance Section with the Department of Criminal Justice Training in Richmond, Kentucky. The Compliance Section is tasked by the Kentucky General Assembly to ensure that carrying concealed deadly weapons applicant classes are taught to the specifications listed in the Kentucky Administrative Regulation 503 KAR 4050. This regulation contains the required content and conduct of the applicant training of the course which you are now attending. As a student, you will be required to sign a Form 126A, which is the applicant request for training license to carry concealed deadly weapons. By signing this form, you are certifying you have attended classroom training of at least 6 hours and participated in live fire exercises with a handgun in a safe and designated location. If the training you receive does not meet these minimum standards and requirements, you should not sign this form. The 6 hours of classroom training you receive shall cover the following topics. Number 1, handgun safety in the classroom, at home, on the firing range, or while carrying a firearm. Number 2, the basic principles of marksmanship. Number 3, the care and cleaning of handguns. This task will be demonstrated by the instructor, but you as the student are not required to demonstrate the hands-on weapons cleaning in the classroom. Number 4, the video you are currently watching will continue to cover the requirements for obtaining a concealed deadly weapons license in Kentucky, along with sections of the Kentucky Revised Statutes pertaining to firearms and justifiable use of force. At the conclusion of the classroom portion of the training, you will be taking a written exam. The exam is open book, and you must correctly answer at least 70% of the questions. In addition to the classroom training, you will be required to participate in live fire exercises. You will be required to fire 20 rounds with a handgun without receiving any assistance in holding, aiming, or firing the handgun from the instructor or any other person. The requirement to qualify without assistance does not prohibit the instructor from assisting you in the clearing of a firearm jam or a malfunction. To successfully pass the range portion of the training, you must fire a total of 20 rounds from a handgun. Obviously, a handgun is not any type of pellet or BB gun. You must use a safe, functional handgun and factory-loaded ammunition. Your instructor should not furnish a handgun for you to qualify, unless special circumstances dictate and you specifically request the instructor provide you with a handgun. Circumstances where this might occur would be if you do not own a handgun to use during the training, or if your instructor inspects your handgun and determines it is not in sound mechanical condition or that it may pose a safety hazard. The instructor cannot charge a fee for the use of the loaned handgun, but can actually charge a fee for the actual ammo that you fire. The instructor may allow you to practice shooting prior to actually qualifying and is encouraged to do so. During the qualification, the instructor is required to observe you as a student as you fire each of the required 20 rounds at a B-21 silhouette target from a distance of 7 yards or 21 feet. You will not be given a passing grade if you fail to follow any instructions given by the instructor on the range, or if you handle a firearm in a manner that poses a danger to yourself, other students, or the instructor, or if you fail to hit the silhouette portion of the target with a minimum of 11 of the required 20 rounds. Remember that during the qualification, the instructor is not allowed to assist you in holding, aiming, or firing the handgun. Within 5 working days after you have completed this class, which includes both the classroom and the range portions, the instructor is required to mail or deliver to the Department of Criminal Justice Training the graded exam sheets, and the applicant request for training license to carry concealed deadly weapons, known as Form 126A, showing your score on the written exam and whether you passed or failed the range qualification. Within 15 working days after the Department of Criminal Justice Training receives your application, known as the Form 126A, you will be issued a certificate of completion, or otherwise known as the training certificate, which will be mailed and/or emailed to the physical and email addresses you listed on your application. An instructor who reports having provided required training and in fact has not provided any part of such training or has provided insufficient training to applicants can be criminally charged with a Class D felony under KRS 237.126 or KRS 237.128, respectively. You, as a student, are required by law to report non-receipt of training under KRS 237.130 or receipt of insufficient training under KRS 237.132. These laws require the applicant report the violation in writing to the local sheriff, the Commonwealth Attorney, or county attorney serving the county in which the training was conducted. Or you can make a written complaint to the Kentucky State Police within 30 working days of receiving your certificate of completion or your training certificate from the Department of Criminal Justice Training, CCDW section. Failure to notify authorities of any violation is a Class A misdemeanor. Permit holders who are found to have attended insufficient training will have their training certificates revoked through an administrative process called a 13B hearing. Permit holders who have their training certificates revoked must retake the entire applicant training course, which includes the classroom and the range qualification portions. Under KRS 237.110 22K, CCDW applicants having their training certificates revoked for not receiving training or having received insufficient training shall have their CCDW license revoked. The compliance section investigates complaints of non-receipt or insufficient training on a regular basis. There have been over 300 investigations of suspected non-training and/or insufficient training, resulting in both felony and misdemeanor convictions of CCDW instructors.
Hello, I'm Doug Barnett, Supervisor of the Legal Training Section for the Department of Criminal Justice Training. Other attorneys from the section will be appearing in this video and will be introduced as they appear. Kentucky has been an open carry state since its inception. The Kentucky Constitution of 1891 authorizes the General Assembly to enact laws preventing the carrying of concealed deadly weapons. Those statutes are found in Kentucky Revised Statutes, KRS Chapters 237 and 527. Pursuant to the authority vested by the Kentucky Constitution, the General Assembly declared Kentucky to be a constitutional carry state with respect to concealed deadly weapons by the enactment of KRS 237.109, which became effective June 27, 2019. KRS 237.109 permits all persons aged 21 or older who are otherwise able to lawfully possess a firearm, carry concealed firearms or other concealed deadly weapons without a license in the same locations as persons with valid concealed carry licenses issued under KRS 237.110, subject to the limitations of KRS 237.110 and federal law. KRS 237.109 does not eliminate carrying concealed permits. In fact, obtaining a concealed carry permit under Kentucky Revised Statutes Chapter 237 provides citizens with important training on firearm laws and safety, as well as ensures reciprocity with other states that confer reciprocity with the possession of a valid license issued in Kentucky to carry concealed deadly weapons. To obtain a concealed carry license, Kentucky Revised Statutes Chapter 237 requires that you receive information on and a copy of laws relating to possession and carrying of firearms as set forth in KRS Chapters 237 and 527, and the laws relating to the use of force as set forth in KRS Chapter 503. This video was designed to meet that statutory requirement. We will discuss several statutes during this video. The statutes discussed will be limited to those that pertain directly to you as an applicant. Procedural requirements such as the duties of the Kentucky State Police are included in your materials but will not be covered in this video. Your instructor should be able to answer questions regarding these procedural steps, or you can inquire through your local sheriff. If you would like a more comprehensive review of the statutes regarding carrying concealed laws in Kentucky, you can visit your local law library or research them online at The public policy statement for this law is contained in KRS 237.110, which provides in subsection 19, the Kentucky General Assembly finds as a matter of public policy that it is necessary to provide statewide uniform standards for issuing licenses to carry concealed firearms and to occupy the field of regulation of the bearing of concealed firearms to ensure that no person who qualifies under the provisions of this section is denied his rights. The Kentucky General Assembly does not delegate to the Department of Kentucky State Police the authority to regulate or restrict the issuing of licenses provided for in this section beyond those provisions contained in this section. This section shall be liberally construed to carry out the constitutional rights to bear arms for self-defense. To understand Kentucky's laws, you must first understand what it is considered to be a deadly weapon. Although many items can be used to hurt another person, Kentucky has a list of items that are considered deadly weapons and are generally prohibited from being carried concealed. KRS 500.080 subsection 4 provides that the following are defined as deadly weapons: a weapon of mass destruction, any weapon from which a shot readily capable of producing death or serious physical injury may be discharged, any knife other than an ordinary pocket knife or hunting knife, a billy nightstick or club, a blackjack or a slapjack, a nunchaku karate sticks, shuriken or death stars, or artificial knuckles made from metal, plastic, or other similar hard material. Any item not specified on this list, which could be used to inflict injury on another person, would be considered a dangerous instrument under KRS 500.080 subsection 3. Under our criminal code, causing someone injury by means of a deadly weapon or with a dangerous instrument carries similar penalties. The focus of the statutes govern whether you can lawfully carry an item concealed. We will now look at the general prohibitions covering carrying deadly weapons on or about your person. These prohibitions are found in KRS Chapter 527, entitled Offenses Related to Firearms and Weapons. KRS 527.010 contains the definitions that are specific to that chapter, two of which are pertinent to your application for a carried deadly weapon license. Firearm means any weapon which will expel a projectile by the action of an explosive. Handgun means any pistol or revolver originally designed to be fired by the use of a single hand, or any other firearm originally designed to be fired by the use of a single hand. KRS 527.020 provides some limitations for carrying a concealed deadly weapon. Under 527.020 subsection 1, a person is guilty of carrying a concealed weapon when he or she carries concealed a firearm or other deadly weapon on or about his or her person in violation of this section. This statute also clarifies circumstances where a deadly weapon is not considered to be concealed under our laws. 527.020 subsection 8, a loaded or unloaded firearm or other deadly weapon shall not be deemed concealed on or about the person if it is located in any enclosed container, compartment, or storage space installed as original equipment in a motor vehicle by its manufacturer, including but not limited to a glove compartment, center console, or seat pocket, regardless of whether said enclosed container, storage space, or compartment is locked, unlocked, or does not have a locking mechanism. Included in your materials are other exceptions that pertain to specified persons who, because of their roles or jobs in the criminal justice system, are given more authority to possess weapons in our state. KRS 527.020 subsection 9 states that the provision of this section shall not apply to a person who carries a concealed deadly weapon on or about his or her person if he or she is the owner of the property or has the permission of the owner of the property on real property which he or she or his or her spouse, parent, grandparent, or child owns, if he or she is the lessee of the property or has the permission of the lessee of the property on real property which he or she or his or her spouse, parent, grandparent, or child occupies pursuant to a lease, or if he or she is the sole proprietor of the business on real property owned or leased by the business. KRS Chapter 527 also provides for the criminal penalty for carrying a concealed deadly weapon. Under KRS 527.020 subsection 10, if a person is not permitted by law to carry a concealed deadly weapon, carrying a concealed deadly weapon is a Class A misdemeanor unless the defendant has been previously convicted of a felony in which a deadly weapon was possessed, used, or displayed, in which case it becomes a Class D felony. Concealed deadly weapon license eligibility factors include the authority to receive a license to carry concealed in Kentucky, and that is found in KRS Chapter 237, Sections 110 through 142. Now, who is eligible for a concealed deadly weapon license? The statute requires that the Kentucky State Police conduct a background check on all applicants. Applicants are not eligible under the following conditions found in KRS 237.110 subsection 4. If a person is prohibited from owning or possessing firearms and or ammunition under federal law, the applicant is not a resident of Kentucky or is not an active duty member of armed forces assigned to a military post in Kentucky or is not a legal alien residing in Kentucky, is under the age of 21, was committed to a state or federal facility for controlled substances violations, or been convicted of a controlled substance offense within the last 3 years, was convicted of 2 or more offenses of motor vehicle DUI within the last 3 years, or was committed to a facility for alcohol abuse treatment within the last 3 years, owes back child support, which cumulative total equals 1 year in arrearage, is subject to a warrant or other proceeding regarding child support or paternity, has been convicted of 4th-degree assault or 3rd-degree terroristic threatening in or within the past 3 years, does not complete the mandatory 8-hour firearm safety course, i.e. this course, cannot demonstrate knowledge of the law regarding the justifiable use of force by including with the application a copy of the Concealed Carry Deadly Weapons Legal Handout made available by the Department of Criminal Justice Training, and a signed statement that indicates that applicant has read and understands this handout. Use of force issues will be covered in this course. The application process. The process to apply for a carry concealed license is found in KRS 237.110 subsection 7, subsection 8, and subsection 9, which are included in your materials. There are 2 ways to apply for a concealed carry license: in person through your local sheriff's office or electronically through the Kentucky State Police. A person may obtain the paper application from the sheriff's office in the county of residence, or the person may apply electronically. If a person desires to submit an electronic application, please consult the Kentucky State Police's official website for details. Paper and electronic applications must be completed under oath, that is, it must be notarized, and paper applications must be returned to the sheriff's office along with the following items: the CCDW application, a recent color photo of the applicant, which is similar to a passport photo, your training certificate, KSP Form 131 if you are not a citizen, and if you're submitting a paper application to your sheriff's office, you'll need to provide 2 checks and or money orders, with 1 check or money order in the amount of $20 made payable to the sheriff's office, with the other check and money order in the amount of $40 made payable to the Kentucky State Treasurer. If submitting an electronic application to the Kentucky State Police, you will need to pay a fee of $70 in the manner directed by the electronic application. Once the sheriff's office receives a completed paper application package, his or her office will forward it to the Kentucky State Police within 5 working days. Once the State Police receives the application package, a background check will be conducted as required by law. Within 60 days from the date of the Kentucky State Police receiving the paper application, or within 15 days from the date the Kentucky State Police receives an electronic application, the State Police will either issue your license or deny your application because you failed to meet the criteria previously discussed. Where can you carry concealed weapons once you have been issued a CDWL? Once you have completed all the requirements and have obtained your concealed deadly weapons license, KRS 237.110 subsection 2 subsection A provides that you may carry a concealed weapon throughout the Commonwealth and, except as provided in this section or other specific sections of the Kentucky Revised Statute or federal law, permit the holder of the license to carry firearms, ammunition, or other deadly weapons or a combination thereof at any location in the Commonwealth. Note that the except as provided clause in the statute, there are within this specific statute as well as in other state and federal laws, places where you cannot carry a concealed weapon either constitutionally or with a valid permit. If you enter these areas with a concealed weapon, you can be charged with and convicted of the crime of carrying concealed deadly weapon. KRS 237.110 subsection 16 provides that, except as provided in KRS 527.020, no license issued pursuant to this section shall authorize any person to carry a concealed firearm into any police station or sheriff's office, any detention facility, prison, or jail, any courthouse solely occupied by the Court of Justice courtroom or court proceeding, any meeting of the governing body of a county, municipality, or special district, or any meeting of the General Assembly or a committee of the General Assembly, except that nothing in this section shall preclude a member of the body holding a concealed deadly weapons license from carrying a concealed deadly weapon at a meeting of the body of which he or she is a member, any portion of an establishment licensed to dispense beer or alcoholic beverages for consumption on the premises, which portion of the establishment is primarily devoted to that purpose, any elementary or secondary school facility without the consent of school authorities as provided in KRS 527.070, any child caring facility as defined in KRS 199.011, any daycare center is defined in KRS 199.894, or any certified family child care home as defined in KRS 199.8982, except, however, any owner of a certified child care home may carry a concealed firearm into the owner's residence used as a certified child care home, any area of an airport to which access is controlled by the inspection of persons and property, or any place where the carrying of firearms is prohibited by federal law. You should also note that subsection 17 allows for private property owners to restrict the carrying of weapons in private businesses, licensed daycare centers, licensed family child care homes, and or healthcare facilities. These properties are to have signs conspicuously posted indicating that concealed weapons are not allowed on the property. The statute states that persons violating this section will not be charged with a carrying concealed offense, but may be removed from the premises. If you refuse to leave the premises, you can still be charged with a criminal trespass offense. Also note that you can still visit the business if you leave your weapon and ammunition locked in your vehicle. There are additional provisions of KRS 237.110 that affect persons with a carrying concealed license. There is a legal requirement that a license holder shall carry the license at all times when they are carrying a concealed firearm or other deadly weapon, and further that they display the license when requested to do so by a law enforcement officer. KRS 237.115 authorizes two other groups to regulate deadly weapons on their property. Nothing contained in KRS 237.109 or 237.110 shall be construed to limit, restrict, or prohibit in any manner the right of a college, university, or any post-secondary education facility, including technical colleges, technical schools, and community colleges, to control the possession of deadly weapons on any property owned or controlled by them, or the right of a unit of state, city, county, Oban County, or charter county government to prohibit the carrying of concealed deadly weapons in that portion of a building actually owned, leased, or occupied by that unit of government. KRS 237.115 subsection 2 further declares that, except as provided in KRS 527.020, the legislative body of a state, city, county, or Oban County government may, by statute, administrative regulation, or ordinance, prohibit or limit the carrying of concealed deadly weapons in that portion of a building owned, leased, or controlled by that unit of government. That portion of a building in which the carrying of concealed deadly weapons is prohibited or limited shall be clearly identified by signs posted at the entrance of the restricted area. The statute or ordinance shall exempt any building used for public housing by private persons, highway rest areas, firing ranges, and private dwellings owned, leased, or controlled by that unit of government from any restriction on the carrying or possession of deadly weapons. The statute, administrative regulation, or ordinance shall not specify any criminal penalty for its violation, but may specify that persons violating the statute or ordinance may be denied entrance to the building, ordered to leave the building, and if employees of the unit of government be subject to employee disciplinary measures for violation of the provisions of the statute or ordinance. The provision of this section shall not be deemed to be a violation of KRS 65.870 if the requirements of this section are followed. The provisions of this section shall not apply to any other unit of government. Relevant provisions of KRS Chapter 527. While several sections of KRS Chapter 527 were discussed earlier in the video, there are additional sections that will be reviewed. Under KRS 527.010 subsection 2, deface means to remove, deface, cover, alter, or destroy the manufacturer's serial number or other distinguishing marks or identification mark. KRS 527.030 pertains to defacing a firearm. Subsection 1 states that a person is guilty of defacing a firearm when he intentionally defaces a firearm. KRS 527.050 pertains to possession of a defaced firearm. A person is guilty of possession of a defaced firearm when he knowingly possesses a defaced firearm unless he makes a report to the police or other appropriate government agency of such possession prior to arrest or authorization of a warrant by a court. Both defacing a firearm and possession of a defaced firearm are misdemeanor offenses. KRS 527.070 contains information about the unlawful possession of a weapon on school property. Subsection 1 states that a person is guilty of unlawful possession of a weapon on school property when he knowingly deposits, possesses, or carries, whether openly or concealed for purposes other than instructional or school-sanctioned ceremonial purposes, or the purposes permitted in subsection 3 of this section, any firearm or other deadly weapon, destructive device, or booby trap device in any public or private school building or bus, on any public or private school campus, grounds, recreation area, athletic field, or any other property owned, used, or operated by any Board of Education, school, Board of Trustees, regents, or directors for the administration of any public or private educational institution. The provisions of this section shall not apply to institutions of post-secondary or higher education. Under KRS 527.070 subsection 2, principals of public or private schools have responsibility concerning the notification to students and the general public concerning unlawful possession of a weapon on school property. Subsection 2 states that each chief administrator of a public or private school shall display about the school in prominent locations, including but not limited to sports arenas, gymnasiums, stadiums, and cafeterias, a sign at least 6 inches high and 14 inches wide, stating, unlawful possession of a weapon on school property in Kentucky is a felony punishable by a maximum of 5 years in prison and a $10,000 fine. Failure to post a sign shall not relieve any person of liability under this section. KRS 527.070 provides several exceptions as to who is prohibited, as well as the authorized purposes that permits the possession of weapons on school property. Subsection 3 states that the provisions of this section prohibiting the unlawful possession of a weapon on school property shall not apply to the following: an adult who is not a pupil of any secondary school and who possesses a firearm, if the firearm is contained within a vehicle operated by the adult and is not removed from the vehicle except for a purpose permitted herein, or brandished by the adult or by any other person acting with express or implied consent of the adult while the vehicle is on school property. Any pupils who are a member of the Reserve Officer Training Corps or pupils enrolled in a course of instruction or members of a school club or team to the extent that they are required to carry arms or weapons in the discharge of their official class or team duties. Any peace officer or police officer authorized to carry a concealed weapon pursuant to KRS 527.020. Persons employed by the Armed Forces of the United States or members of the National Guard or militia when required in the discharge of their official duties to carry arms or weapons. Civil officers of the United States in the discharge of their official duties. Nothing in this section shall be construed as to allow any person to carry a concealed weapon into a public or private elementary or secondary school building. Any other persons, including but not limited to exhibitors of historical displays who have been authorized to carry a firearm by the Board of Education or Board of Trustees of the public or private institution. A person hunting during the lawful hunting season on lands owned by any public or private educational institution and designated as open to hunting by the Board of Education or Board of Trustees of the educational institution. A person possessing unloaded hunting weapons while traversing the grounds of any public or private educational institution for the purpose of gaining access to public or private lands open to hunting with the intent to hunt on the public or private lands unless the lands of the educational institution are posted prohibiting the entry, or a person possessing guns or knives when conducting or attending a gun and knife show when the program has been approved by the Board of Education or Board of Trustees of the educational institution. The penalty for a violation of KRS 527.070 is a Class D felony. 527.100 deals with the issue of possession of a handgun by a minor. A person is guilty of possession of a handgun by a minor when, being under the age of 18 years, he possesses, manufactures, or transports a gun as defined by KRS 527.010, except when the person is in attendance at a hunter's safety course or a firearm safety course, engaging in practice in the use of a firearm or target shooting at an established firing range or any other area where the discharge of a firearm is not prohibited, engaging in an organized competition involving the use of a firearm or participating in or practicing for a performance by a group organized under Section 501, Subsection 3 of the Internal Revenue Code or any successor thereto which uses firearms as a part of the performance, hunting or trapping pursuant to a valid license issued to him pursuant to the statutes or administrative regulations of this Commonwealth, traveling to or from any activity described in paragraphs A to D of this subsection with any unloaded handgun in his possession, on real property which is under the control of an adult and has the permission of that adult and his parent or legal guardian to possess a handgun, or at his residence and with the permission of his parent or legal guardian, possesses a handgun and is justified under the principles of justification set forth in KRS Chapter 503 in using physical force or deadly physical force. To assist in making a determination of one of the above situations, KRS 527.100 subsection 2 provides information to determine whether a handgun is loaded. Subsection 2 states, for the purposes of subsection 1 of this section, a handgun is loaded if there is a cartridge in the chamber of the handgun, or there is a cartridge in the cylinder of the handgun if the handgun is a revolver, or there is a cartridge in the magazine of a semi-automatic handgun if the magazine is attached to the handgun, or the handgun and the ammunition for the handgun are carried on the person of one under the age of 18 years, or are in such close proximity to him that he could readily gain access to the handgun and the ammunition and load the handgun. KRS 527.100 subsection 3 makes possession of a handgun by a minor a Class A misdemeanor for the first offense and a Class D felony, for each subsequent offense. KRS 527.110 addresses the laws pertaining to unlawfully providing a handgun to a juvenile or permitting a juvenile to possess a handgun, and this law is applicable to parents or legal guardians of a juvenile. Subsection 1 states that a person is guilty of unlawfully providing a handgun to a juvenile or permitting a juvenile to possess a handgun when he intentionally, knowingly, or recklessly provides a handgun with or without remuneration in violation of KRS 527.040, 527.100, or 600.020 to any person he knows or has reason to believe is under the age of 18 years, or is the parent or legal guardian of a juvenile and intentionally, knowingly, or recklessly provides a handgun to the juvenile or permits the juvenile to possess a handgun knowing that there is a substantial risk that the juvenile will use a handgun to commit a felony offense, or with knowledge that the juvenile has been convicted of a crime of violence as defined in KRS 439.3401, or has been adjudicated a public offender of an offense that would constitute a crime of violence as defined in KRS 439.3401 that provides a handgun to that juvenile. Unlawfully providing a handgun to a juvenile or permitting a juvenile to possess a handgun is a Class D felony. Finally, let's review KRS 527.060. This statute should be particularly important to you. This is a firearms forfeiture statute. Upon the conviction of any person for the violation of any law of this Commonwealth in which a deadly weapon has been used, displayed, or unlawfully possessed by such person, the court shall order the weapon forfeited to the state and sold, destroyed, or otherwise disposed of in accordance with KRS 500.090. Protect your firearms. Know where you can carry them and know what you can do with them.
I am Michael Schweindeman, and I am a staff attorney for the Department of Criminal Justice Training. The next unit we are going to cover is called Use and Misuse of Force. We have discussed how to apply for a license and where you can carry a deadly weapon with a license. Another very important consideration is when you can legally use that weapon on another person. The law starts from the general proposition that the intentional use of any type of force against another person is wrong. If you intentionally use force against another person and cause injury, you will escape criminal punishment only under certain circumstances. You may even be criminally punished if you did not intend to injure anyone, but you were very careless and someone was injured anyway. If your actions result in a death, you may be guilty of some type of criminal homicide, murder, manslaughter, or reckless homicide. If you injure someone, you may be guilty of some degree of assault. The situations in which you can legally use force on a person are provided in KRS Chapter 503 and are called justifications. The ones which will most likely apply to you are self-protection, commonly called self-defense, protection of another, and protection of property. The emphasis will be on the use of firearms for these three purposes. Let's take a moment to review. Question 2.1.1. True or false? The law starts from the general proposition that the intentional use of any type of force against another person is wrong. The answer? You should have marked number 1 true, because the law does start from the general proposition that the intentional use of any type of force against another person is wrong. Question 2.1.2. True or false? If you intentionally use force against another person and cause injury, you will escape criminal punishment only under certain circumstances. The answer? You should have marked number 2, true. If you intentionally use force against another person and cause injury, you will escape criminal punishment only under certain circumstances. You will probably be charged with some offense. Let's begin our discussion of justifications with KRS 503.020. In any prosecution for an offense, justification, as defined in this chapter, is a defense. First of all, note that justification is a defense. A defense does not mean you cannot be prosecuted. It means that at your trial, if the evidence shows you have a defense, you will be found not guilty. That you are justified in using force does not mean that you have to use it. It means that if you do use it, the law is on your side. Next, we need to consider the 2 levels of force mentioned in the justification situations: physical force and deadly physical force. Each of the justifications contained in KRS Chapter 503 considers both levels, when you can use physical force and when you can use deadly physical force. You should have some understanding of these terms in order to understand when you are justified in using a deadly weapon to injure someone. Turn to subsection 4 of KRS 503.010. Physical force means force used upon or directed toward the body of another person and includes confinement. If you hit someone or try to hit someone but miss or hold on to another person, you have used physical force, whether or not any injury results. As you can imagine, physical force situations do not typically involve firearms. When a person fires a gun at someone, this typically is a deadly physical force situation. So we'll be emphasizing deadly physical force. Subsection 1 defines deadly physical force. Deadly physical force means force which is used with the purpose of causing death or serious physical injury, or which the defendant knows to create a substantial risk of causing death or serious physical injury. The term defendant in KRS Chapter 503 means a person who has used force and is now facing criminal charges for harm caused by the force. Whether or not you have deadly physical force does not depend on the seriousness of the injury caused or even whether there was any injury caused. The question is, did you use the force, for example, fire a gun at someone, for the purpose of killing or seriously injuring the person? Or did you know that the force you used created a substantial risk that the person could be killed or seriously injured, even though you didn't intend to kill or seriously injure? For example, you just meant to fire a warning shot close to the person, or you just meant for the bullet to cause a minor injury. The main point here is the use of force is legal only if it is justified by KRS Chapter 503. So, don't use physical force or deadly physical force, for example, firing a gun at someone, unless you know it is permitted by law for self-protection, or protection of another, or protection of property, or some other justification situation. Again, do not use physical force or deadly physical force unless you know it is permitted by law. Question 2.2.1. True or false? Justification is a defense, but you can still be prosecuted. Answer: if you said justification is a defense, that is true. If you understand that it is also true that you can still be prosecuted, you may avoid some unpleasant side effects if you improperly use a weapon you are carrying concealed. Just because you are legally justified in using force, that does not mean you have to use it. It means that if you do use it, the law is on your side, but you may still have to go to court to justify your use of a deadly weapon. Question 2.2.2. True or false? If you use physical force upon or directed toward another person, you can be charged with a criminal offense even if nobody is injured as a result. The answer is true. If you use physical force upon or directed toward another person, you could be charged with some crime whether or not any injury occurs. Question 2.2.3. True or false? If you use force with the purpose of causing death or serious physical injury, you have used deadly physical force. The answer? True. Deadly physical force is defined in terms of the actor's intentions, not specifically what he was doing. If you use force with the purpose of causing death or serious physical injury, you have used deadly physical force. If you use deadly physical force with the purpose of causing death or serious physical injury, what you are charged with depends upon the result of your actions. If there is no injury, but you do endanger someone, you could be charged with wanton endangerment. If there is an injury, you could be charged with some degree of assault. If someone dies, you can be charged with some degree of criminal homicide. So basically, if you use your weapon improperly, you may be committing a criminal offense. Question 2.2.4. A person who has used force and is now facing criminal charges for harm caused by the force is called A. Victim, B. Criminal, C. Defendant, D. None of the above. Answer. A person who has used force and is now facing criminal charges for harm caused by the force is called C. A defendant. When you are issued a license, you may carry a concealed deadly weapon. If you use that weapon, you will have to justify your actions. Question 2.2.5. True or false? Whether or not you have used deadly physical force does not depend on the seriousness of the injury caused or whether there was any injury caused. The answer is true. You could use deadly physical force against another person but not injure them. For example, firing a shot at somebody but missing. You have still used deadly physical force. Question 2.2.6. Yes or no? If you fire a warning shot close to a person, or you just mean for the bullet to cause a minor injury, you are at risk of becoming a defendant. Answer? The answer is yes. Even though you may not intend to cause death or serious physical injury, you are using deadly physical force. If you are creating a substantial risk of death or serious physical injury by your actions, and you know it, that also meets the definition of deadly physical force. The question is always, is the use of force legally justified by KRS Chapter 503? Again, you should use physical force or deadly physical force only when you know it is permitted by law. Now, let's look at some of the justifications. That is, some of the situations where the law says you are justified in using force. The first one that may come quickly to your mind is self-defense, or self-protection as it is called in the statute. Turn to KRS 503.050. Notice here that subsection 1 deals with physical force. Subsection 2 will tell you when deadly physical force can be used. The use of physical force by a defendant upon another person is justifiable when the defendant believes that such force is necessary. The law leaves room for bad judgment. You can be wrong about the need, but your belief may not be wanton or reckless. You must actually believe that it was necessary, 1, to use force, and 2, to use that much force. For example, You, believing a person is about to attack you, hit the other person. Even if you are mistaken in your belief, and in reality, the person is not about to attack you, you're still justified in using the force so long as you were not wanton or reckless in believing you were about to be attacked. The use of physical force by a defendant upon another person is justifiable when the defendant believes that such force is necessary to protect himself against the use or imminent use of unlawful physical force by the other person. Imminent means it's just about to happen. You don't have to wait until you've been hit to start protecting yourself. Also, the physical force being used or about to be used on you must be unlawful. The law allows certain people to use force in certain situations. For example, a law enforcement officer, when arresting someone, is allowed to use whatever force is reasonably necessary to get the job done. Also, a merchant is allowed to use force to detain a shoplifter. If you are being arrested by a law enforcement officer, you cannot legally use force to resist, even if the arrest is unlawful. For example, there has been a mistake in identification and they are arresting the wrong person. You can do something about the matter later in court. Question 2.3.1. Yes or no? Is the use of physical force by a defendant upon another person justifiable when the defendant believes that such force is necessary? The answer is yes. The use of physical force on another person is justifiable when the defendant believes that such force is necessary. Question 2.3.2. Yes or no? If you believe a person is about to attack you, you may use physical force on the person. Answer: yes. This question was just another way of asking the first question. The law provides that the use of physical force by a defendant upon another person is justifiable when the defendant believes that such force is necessary to protect himself against the use or imminent use of unlawful physical force by the other person. Question 2.3.3. What does imminent mean? A. Someone did something. B. Something is about to happen. C. Something just happened. D. Something will happen in the future. The answer is B. Something is about to happen. Imminent means something is about to happen any moment now. You can take steps to protect yourself against unlawful physical force that is about to be used against you. You do not have to wait until you have actually been assaulted to act. Question 2.3.4. True or false? To resist with physical force, the physical force being used or about to be used against you must be unlawful. The answer is true. For example, a law enforcement officer, when arresting someone, is allowed to use whatever force is reasonably necessary to make the arrest. Also, a merchant is allowed to use reasonable force to detain a shoplifter. Question 2.2.5. Select all that are correct. Who can lawfully use force against you that you are forbidden to resist? A. A family member. B. Law enforcement officer. C. Merchant. D. Neighbor. E. None of the above. Answer: who can lawfully use physical force against you that you are forbidden to resist? The correct answers are B. A law enforcement officer, and C. A merchant. A law enforcement officer is allowed to use whatever force is reasonably necessary in arresting someone. If you are being arrested, even if you know it is an unlawful arrest, you do not have a legal right to resist. For example, an officer makes a mistaken identification and arrests the wrong person. The remedy is to get it resolved in court. A merchant can legally use reasonable force to detain shoplifters. When can you use deadly physical force, for example, shoot someone, to protect yourself? Let's go to subsection 2 of KRS 503.050 and find out. The use of deadly physical force by a defendant upon another person is justifiable under subsection 1. In other words, what follows is in addition to what was required in subsection 1 concerning the use of physical force. The use of deadly physical force by a defendant upon another person is justifiable under subsection 1 only when the defendant believes that such force is necessary to protect himself against death, serious physical injury, kidnapping, sexual intercourse compelled by force or threat, felony involving the use of force, or under those circumstances permitted pursuant to KRS 503.055. You may shoot someone or otherwise use deadly physical force to protect yourself only if you believe that you are about to be or are being killed, seriously injured, kidnapped, forcibly raped or sodomized, or when someone has unlawfully and forcibly entered your dwelling, residence, or occupied vehicle. The Kentucky Court of Appeals has held that the word sexual intercourse includes sodomy, that is, oral sex or anal intercourse. So, forcible sodomy is a fifth situation. Also involved are felonies involving the use of force, such as a robbery, or an apparent home invasion, or carjacking, where you have a reasonable fear of imminent peril of death or great bodily harm. These are the only situations considered serious enough to justify the use of deadly physical force in self-protection. Remember, the words defendant believes such force is necessary leave room for bad judgment. For example, say some jokester points an unloaded gun at you and acts like he is going to shoot you. And you, believing you are about to be seriously injured or even killed, react by shooting the person. Even though you were wrong in your belief, you weren't actually about to be shot, you still used deadly physical force justifiably, unless it was wanton or reckless of you to think you were about to be shot. KRS 503.060 also pertains to self-protection and makes a point that we need to consider. Look at subsection 3. See the term initial aggressor? The initial aggressor is the first one to use or threaten to use force illegally. For example, the first one to throw a punch or fire a gun at someone. The law, as a general rule, works against the initial aggressor. Mere name-calling, however offensive, is not initial aggression. If someone calls you names, no matter how insulting the language, you are not legally justified in using force on the name caller. If you do, you are the initial aggressor, and you are the one in trouble under the law. Threats are a different matter. If a person threatens you in such a way that it is not wanton or reckless for you to believe the person is about to use force on you, hit you or shoot you illegally, you may act preemptively by using a reasonable amount of force to protect yourself. KRS 503.070 is another situation where you can legally use force, protection of another. Here also, as it did for self-protection, the law says when you can use physical force and when you can use deadly physical force. Since we are primarily interested in firearms, we will go to deadly physical force, subsection 2. The use of deadly physical force by a defendant upon another person is justifiable when A. The defendant believes that such force is necessary to protect a third person against imminent death, serious physical injury, kidnapping, sexual intercourse compelled by force or threat, or other felony involving the use of force, or under circumstances permitted pursuant to KRS 503.055. You can use deadly physical force to protect someone against the same harms as to protect yourself: imminent death, serious physical injury, kidnapping, forcible rape or forcible sodomy, felonies involving the use of force, home invasions or carjackings that you have reasonable fear of imminent death or great bodily harm. Essentially, you may defend a third party with deadly physical force against all of the same dangers you may defend yourself against. But the language in paragraph B limits the application of this law. 2B, under the circumstances as they actually exist, the person whom he seeks to protect would himself have been justified under KRS 503.050 and 503.060 in using such protection. In self-protection, there was room for bad judgment on your part, under the circumstances as you believe them to be. In protection of another, note carefully that the language of the statute is different, under the circumstances as they actually exist. If the person you are seeking to protect could use deadly physical force to protect himself, then you can also use deadly physical force to protect him. This would be true even if the person you seek to protect has an opportunity to protect himself but does not use it. But the result is different if the facts are not what they appear to be. Let's say you come across a man who has a gun pointed at an apparently unarmed man. You think the unarmed man is about to be shot by the armed man, so you pull out your own pistol and you shoot and kill the armed man. After you shoot, you find out that the armed man is an undercover police officer who is arresting a dangerous fugitive from justice. The facts as they appear to you would seem to justify the unarmed man in using deadly physical force in self-protection. The facts as they actually existed would not. Put more simply, you have to be right about it, not just believe it. So you would not have a justification defense. You could be found guilty of murder. Many other situations may not be what they appear to be on the surface and could lead to similar results. You must be very careful before you use deadly physical force to protect another. Question 2.4.1. Select all that are correct. Which of the following would make the use of deadly physical force justifiable in response to the actions of another? A. You believe you may be killed. B. You believe you may suffer serious physical injury. C. You believe you may be forcibly raped. D. You believe you may be struck in the face. E. None of the above. The correct answers are A, B, and C. You may use deadly physical force to protect yourself only if you believe you are about to be or are being killed, seriously injured, or forcibly raped. KRS 503.050 provides that the use of deadly physical force is justifiable only when the defendant believes that such force is necessary to protect himself against death, serious physical injury, kidnapping, or sexual intercourse compelled by force or threat. Remember, the Court of Appeals has held that you are privileged to use deadly physical force to protect yourself from oral or anal sodomy compelled by force or threat of force. Question 2.4.2. True or false? The term initial aggressor means the person who first threatens to use force or uses force. Answer: true. The initial aggressor is the first one to use or threaten to use force illegally. For example, the first one to unlawfully throw a punch or fire a gun at somebody. Remember, the law generally works against the initial aggressor, so if you start an incident, you will have great difficulty justifying your actions as self-defense. Question 2.4.3. Yes or no? If someone insists on calling you names and becomes very insulting and uses really bad language, are you legally justified in using force against the name caller? The answer is no. Mere name calling is not initial aggression, regardless of how offensive it may be. If you use force on the name caller, you are the initial aggressor, and you are the one in trouble under the law. Question 2.4.4. True or false? You may use your weapon if you believe that deadly force is necessary to protect another person from imminent death, serious physical injury, kidnapping, or sexual intercourse compelled by force or threat of force. The answer is true. You may use your weapon if you believe that deadly force is necessary to protect another person from imminent death, serious physical injury, kidnapping, or sexual intercourse compelled by force or threat of force. These are the same circumstances you are privileged to use deadly force in protection of yourself or under circumstances permitted pursuant to KRS 503.055. But note carefully the answer to the next question. Question 2.4.5. You encounter a situation in which you genuinely believe deadly physical force is necessary to protect another person and you use it. Later, you find out the real situation was not what you thought, and in fact, deadly force was not necessary. Do you lose your justification under the law? The answer is yes, if the facts as they appeared to you would seem to justify using deadly physical force to protect another person, but under the facts as they actually existed, you would not. You have no justification defense and could be found guilty of a crime. Many situations may not be what they appear to be on the surface. You must be very careful in such matters, as a mistaken act could lead to your being charged with and possibly convicted of a serious criminal offense. KRS 503.080 is a third set of circumstances where you are justified in using force protection of property. Subsection 1 tells you when you can use non-deadly physical force to protect property. Let's go to subsection 2, which tells you when you can use deadly physical force to protect property. The use of deadly physical force by defendant upon another person is justifiable under subsection 1 only when the defendant believes that the person against whom such force is used is A. attempting to dispossess him of his dwelling otherwise than under a claim of right to its possession. Turn to subsection 2 of KRS 503.010. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent, mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. For example, you could use deadly physical force to stop someone who has no claim of ownership or right of possession from trying to throw you out of your dwelling and take it over. But you could not use deadly physical force to resist eviction. Notice also that the dwelling you are protecting must be your own. You do not have to own it, but you must be living there at the time. Or B. committing or attempting to commit a burglary, robbery, or other felony involving the use of force, or under the circumstances permitted pursuant to KRS 503.055 of such dwelling. Such dwelling refers back to paragraph A, so it means the dwelling must be your own. For the person to be a burglar, he must be in a building without permission and with the intent to commit some crime. It does not matter what crime the burglar intends to commit to qualify as a burglary. As long as the person is in your dwelling as a burglar, you are justified in using deadly physical force. There is room for bad judgment on your part. You are justified if you believe that it's a burglary, even if it turns out not to be, so long as your belief is not wanton or reckless. You cannot justifiably use deadly physical force once the burglar is out of your dwelling and is trying to leave the scene. He is no longer a threat. The words attempting to commit include situations where a burglar is trying to get in your dwelling, but has not yet gotten in. For example, he is trying to pry open the window. His actions must leave no reasonable doubt about his intention to commit a burglary. A robbery is when a person accomplishes a theft by using or threatening to use unlawful force against the victim. Notice, this law does not allow you to use deadly physical force on someone who is merely a trespasser. Or, C. Committing or attempting to commit an arson of a dwelling or other building in its possession. This allows you to use deadly physical force to prevent someone from burning or trying to burn your dwelling or other building in your possession, such as a barn. If you use force against one person, there is danger that an innocent third person will be injured, particularly when you use deadly physical force. You may be justified in shooting at someone to protect yourself, for example, but if you miss, someone else may be injured or killed. Subsection 2 of KRS 503.120 deals with injuring innocent persons. When the defendant is justified under KRS 503.050 to 503.110 in using force upon or toward the person of another, but he wantonly or recklessly injures or creates a risk of injury to innocent persons, the justification afforded by those sections is unavailable in a prosecution for an offense involving wantonness or recklessness towards innocent persons. For instance, you shoot 2 shots at a person who is about to illegally shoot you. One of the shots hits the attacker, but one shot goes wide and strikes an innocent bystander. This occurs in a crowded place where you know there's a good chance that somebody might be hit if you miss your attacker. You would certainly have a self-protection defense to a criminal charge brought against you for shooting your attacker. But if you were wanton or reckless in firing the shot that missed, you may be criminally liable for harm caused to the bystander. Question 2.5.1. True or false? You are never justified in using deadly physical force solely to protect personal property, such as your car or a TV set. The answer is true. You are never justified in using deadly physical force to protect personal property, no matter how valuable it may be. The times you can use deadly physical force to protect property only involve buildings, and usually just your dwelling. Question 2.5.2. True or false? Using deadly physical force is justifiable if you believe the person is attempting to throw you out of your house and take it over without a right to do so. The answer is true. You may use deadly force to prevent a person from trying to throw you out of or take over your dwelling, but you could not use deadly force to resist an eviction under a mortgage foreclosure or a landlord's action. Also, remember that this right is limited to your dwelling only. Question 2.5.3. Yes or no? If a burglar is escaping out the backyard with your diamond jewelry, can you shoot him? The answer is no. As long as the burglar is in your dwelling, you are justified in using deadly physical force. However, once the burglar is out of the dwelling, the right to use the force ends as soon as he exits. Being in the yard does not count. Once the burglar is out, the threat is over and the right to use deadly force against the burglar ends. Question 2.5.4. Yes or no? If your nosy neighbor continually sneaks into your backyard to learn your business, can you use deadly force to stop him or scare him off? The answer is no. You cannot use deadly force against a mere trespasser. While you may use whatever physical force may be necessary to remove him from your property, you cannot use deadly physical force. Question 2.5.5. Yes or no? If you see someone trying to burn your barn or detached garage, can you use deadly physical force to prevent him from burning it? The answer is yes. The law permits you to use deadly physical force to prevent someone from burning or trying to burn your dwelling or other building in your possession. This would include your barn or other outbuilding as well as a store you owned. But it must be a building in your possession, not somebody else's. Question 2.5.6. Yes or no? If you hurt an innocent third person while justifiably using deadly force on another person, could you face charges of acting wantonly or recklessly? The answer is yes, you could. You must always be careful when using deadly physical force to not cause harm to third persons. If you are legally justified in shooting at a person, but in the process innocent people were hurt, you could have criminal liability for their injuries if a court determined that you were acting wantonly or recklessly toward them. KRS 503.085 does not set forth a justification defense. However, it does affect your rights in the event you use deadly force and claim a justification defense. Let's look at subsection 1. A person who uses force as permitted in KRS 503.050, 503.055, 503.070, and 503.080 is justified in using such force and is immune from criminal prosecution and civil action for the use of such force, unless the person against whom the force was used is a peace officer who is acting in the performance of his or her official duties, and the officer identified himself or herself, or the person using force knew or reasonably should have known that the person was a peace officer. As used in this subsection, the term criminal prosecution includes arresting, detaining in custody, and charging or prosecuting the defendant. This language provides that if you have used deadly physical force and are found to have a justification defense under KRS 503.050, 503.055, 503.070, and 503.080, you cannot be criminally prosecuted nor civilly sued. However, you would not be immune from prosecution if the person you used force against was either known to you or should have been known to you as a peace officer. Prosecution includes arresting, detaining in custody, and charging or prosecuting the actor. However, Just because you claim you are justified does not automatically mean you cannot be prosecuted. Let's look at subsection 2. The law enforcement agency may use standard procedures for investigating the use of force as described in subsection 1 of this section, but the agency may not arrest the person for using force unless it determines that there is probable cause that the force that was used was unlawful. If you have used deadly physical force against another person and are claiming a justification defense under KRS Chapter 503, law enforcement officers will still investigate the case. If you tell them that you acted pursuant to one of the justification defenses in Chapter 503, they will investigate and determine if it is more likely than not true that your defense will hold up in court. If they believe it is more likely than not true that it will succeed, they will not arrest you. That does not mean they will not investigate the case further. If they develop enough evidence to indicate guilt, the case may get referred to a grand jury. If you are indicted, you will be prosecuted for the offense charged. If the court finds that your defense is justified, you will be acquitted, but if not, you will be convicted of the offense and punished. On the other hand, if the officers determine that it is more likely than not true that your justification claim will fail, they may arrest you at the scene and charge you with a crime. The case will then proceed normally. Again, if your justification defense is upheld in court, you will be acquitted. If not, you will be found guilty of the offense charged and be punished. Question 2.6.1. True or false? If you are justified in using deadly physical force for KRS 503.050, 503.055, 503.070, or 503.080, you are immune to criminal prosecution. The answer is true. If you are determined to be justified in your use of force for KRS 503.050, 503.070, 503.055, or 503.080, you are immune to criminal prosecution. Question 2.6.2. True or false? If you are claiming justification in using deadly physical force against the person you knew to be a peace officer in the performance of his or her duties, you are immune from criminal prosecution. The answer is false. You are not immune from criminal prosecution if the person you used force against was a peace officer in the performance of his or her duties and identified him or herself, or you either knew they were a peace officer or you reasonably should have known it. Question 2.6.3. You are claiming justification under Chapter 503 for using deadly physical force against another person. May you be arrested by peace officers and charged with a crime. A. Always. B. Never. C. Only if the officers have probable cause to believe your justification defense will fail. D. Only if a judge says they can. The correct answer is C. Ordinarily, you would be immune from criminal prosecution, which is defined as including arrest, if you are claiming justification in using deadly physical force under KRS Chapter 503. However, if law enforcement officers have probable cause to believe your justification defense will fail, they may arrest you and charge you with an offense. This means if they have evidence which makes it more likely than not true that your justification defense will fail in court, they may arrest you and charge you. Question 2.6.4. True or false? If law enforcement officers do not arrest you at the scene of an incident where you use deadly physical force and you are claiming a justification defense, you can never be criminally prosecuted for the incident. The answer is false. If officers do not believe they have probable cause to believe your justification defense will fail, they cannot arrest you at the scene. However, they may continue their investigation into the incident. If they believe they have sufficient evidence, they may take the case to a grand jury. If the grand jury determines that there is sufficient evidence to believe you probably committed the crime, and that your justification defense will probably not succeed, they may indict you and charge you with an offense. In that case, you will stand trial. If you satisfy the trial court that your justification defense was valid, you will be acquitted. If not, you will likely be convicted of the offense and punished.
It is now time to look at some liability issues. Generally speaking, you are responsible for your own actions, and you may be legally liable for any harm you cause. Legal liability may be defined as the condition of being obligated by law to do something, such as to go to jail or to pay a fine. There are two types of legal liability, criminal and civil. You may be found both criminally and civilly liable for the same act. For example, if you, without justification, shoot and hurt someone, you may be guilty of a crime and punished accordingly. Plus, you also may be civilly liable for his medical expenses and other damages. First, let's consider criminal liability. If you violate a criminal law, the government may bring criminal charges against you. If you plead guilty or if you are found guilty, you can be punished by confinement in a state prison or a local jail, or fined a sum of money, or both. Fines go to the state, not the victim. It is easy to understand that if you intend to cause harm and do cause the harm, you may be criminally liable. You can also be criminally liable if you intend to cause harm, but you're unsuccessful. For example, if you intend to kill your neighbor and shoot at him, you will have criminal liability either for his murder, if successful, or for attempted murder, if you fail. We have previously discussed the Kentucky statute that provides justification when to use force to protect yourself, others, or your property. Remember, there are strict limitations on your use of deadly physical force, and if your acts do not fall within the boundaries of those limitations, you can be found guilty of a criminal offense regarding your use of force. You may also be criminally liable for harm caused even if you didn't intend to cause the harm. If you were reckless or wanton in your conduct and harm was caused, you can be found guilty of a crime. Recklessness and wantonness are extreme types of carelessness. Recklessness. You are doing something, for example, firing a gun. You do not intend your conduct to cause any harm, but your conduct does create a substantial risk of harm. You, because of extreme carelessness, fail to notice the risk of harm you are causing, and you go on with what you are doing. For example, you decide to practice firing your handgun at a target, but you do not check to see if anyone is in the area behind the target who could be hit by a bullet. If you did, you would see children playing in the area. A child is hit by your first bullet. Your conduct is reckless. If the child dies, you may be guilty of reckless homicide. If the child lives, you may be guilty of assault. Wantonness. You are doing something, for example, firing a gun. You do not intend your conduct to cause any harm, but your conduct does create a substantial risk of harm. You realize the risk of harm you are creating. You ignore the risk and go on with what you are doing. Let's go back to the previous target practice example. This time, you do check the area behind the target, and you see children playing there. But you decide to go ahead and shoot anyway, hoping that nobody will be hit. A child is hit by your first bullet. Your conduct is wanton. If the child dies, you may be guilty of manslaughter or even murder. If the child lives, you may be guilty of assault. Even if nobody is hit, you may still be guilty of a crime called wanton endangerment in the first degree if your conduct created a great risk that someone would be killed or seriously injured. Even if you do not hit or endanger a person when you shoot, if your conduct is wanton in regard to damaging property and damage is caused, you may be guilty of criminal mischief. It should also be noted that under Kentucky law, voluntary intoxication is deemed to be wanton conduct. If you've been drinking and use a firearm, by definition, you are acting wantonly. Kentucky statutes also provide criminal penalties to you. If, as a student, you accept certification for firearms training and you did not, in fact, receive such training. KRS 237.130 is called failure to report non-receipt of firearms training when receiving certification without notice to specified law enforcement or prosecutorial personnel. It requires that if you receive certification without training, you must report that fact to the county sheriff, the Commonwealth's attorney, the county attorney, or make a written report to the Kentucky State Police. You must also provide a written copy of the certification documents to the agency you made the report to. You must make this report within 30 working days of receiving the documentation that you had completed the training. Failure to report non-receipt of firearms training is a Class A misdemeanor. If you make the report as required, you will be excused from criminal prosecution, and you are eligible to take the class you were originally enrolled in to complete your certification for a CCDW license or as a CCDW instructor.
Okay.
Question 1.1. You may be legally liable for any harm you cause. If found to be legally liable, you are obligated by law to do something, such as go to jail or pay a fine. True or false? The answer to question 1.1 is true. Legal liability is being obligated by law to do something. Question 1.2. Which of the following best describes the two types of legal liability? A. Criminal and civil. B. Illegal and uncivil. C. Bad and worse. D. None of the above. The answer to question 1.2 is A. Criminal liability and civil liability are the two types of legal liability. You may be found both civilly and criminally liable for the same act. Question 1.3. If you shoot at someone you intend to kill and you kill him, you may be guilty of murder. But if you don't get the job done, are you criminally liable? The answer to question 1.3 is yes. If you shoot at someone with the intent to kill and you don't get the job done, you are still criminally liable for attempted murder. Or if you injure the person, you may be guilty of some degree of assault. If you shoot at someone's house, car, animal, or other property, you may be guilty of a crime called criminal mischief or attempted criminal mischief if you miss. Question 1.4. If you fire a gun without any intention of causing harm, but you create a great risk that harm will result, if you are careless and fail to notice this risk, you are acting A, recklessly, B, wantonly, C, both of the above, D, intentionally. The answer to question 1.4 is A, recklessly. If you do fire a gun and create a great risk of causing harm, if you are careless and fail to notice the risk you are causing, you are said to be acting recklessly. If a person dies because of your recklessness, you may be guilty of reckless homicide. If the person is injured but lives, you may be guilty of some degree of assault. Question 1.5. If you do not intend to cause harm, but you create a great risk that harm will result, if you notice the risk of harm but continue anyway, you are acting A, recklessly, B, wantonly, C, none of the above, D, knowingly. The answer to question 1.5 is B, wantonly. If you do fire a gun and create a great risk of causing harm, if you are aware of the risk you have created but disregard the risk and go ahead and fire your gun, you are said to be acting wantonly. If a person dies because of your wantonness, you may be guilty of murder or manslaughter. If the person is injured but lives, you may be guilty of some degree of assault. Even if nobody is hurt, you may still be guilty of a crime called wanton endangerment in the first degree. If your firing the gun created a great risk that someone would be killed or seriously injured. This segment has looked at the potential for you to be held criminally liable for your actions, especially in issues involving use of force. In the next segment, potential civil liability issues will be discussed. Remember, you can be liable both criminally and civilly for the same act. Now let's consider civil liability, which is known as tort liability. A tort is a civil wrong that damages the person, property, or reputation of another person. If you lose a tort lawsuit, most likely the judge will order you to pay money to the person suing you. Enough money to make up for the harm you have caused. There are two main types of torts: intentional and negligent. First, an intentional tort. For example, you fire a gun at someone intending to kill him, and you succeed. If you had no legal right to do this, not only are you criminally liable, but you are also civilly liable to the victim's family for the harm you have caused to them. If the evidence shows that you had a legal right to shoot the victim, for example, you acted in self-protection, you are not liable, either criminally or civilly. The other main type of tort is a negligent tort. Negligence is a form of carelessness. It is not as serious as recklessness or wantonness, but it is serious enough to support civil liability. For a person to win a negligence suit against you, he will have to prove the following. You had a duty to be careful under the circumstances. For example, the duty to check out the area behind the target before taking target practice. You, because of your negligence, failed to meet this duty. For example, you don't think to check out the area behind the target, and your failure to meet your duty is the cause of the harm. You must remember that you can be held both criminally and civilly liable for your acts, even in the event you were careless in causing harm or damage. If your carelessness would fit in the criminal definitions of reckless or wanton conduct, you can also be tried in a criminal court. Question 2.1. A civil wrong that damages the person, property, or reputation of another person is called a tort, B, tort, C, target, D, tail. The answer to question 2.1 is B. A tort is a civil wrong that damages the person, property, or reputation of another person. Question 2.2. If you lose a tort lawsuit, the judge is most likely to order you to A, serve time in jail, B, apologize, C, pay damages, D, none of the above. The answer to question 2.2 is C. If you lose a tort lawsuit, the judge is most likely to order you to pay money, enough money to make up for the harm you have caused. Question 2.3. What are the two main types of torts? A, intentional tort, B, negligent tort, C, unintentional tort, D, both A and B, intentional and negligent torts. The answer to question 2.3 is D. The two types of torts are intentional and negligent. Question 2.4. If you fire a gun at someone intending to kill him, and you get the job done, if you had no legal right to do this, which type of tort can you be sued for? A, intentional tort, B, negligent tort, C, unintentional tort, D, none of the above. The answer to question 2.4 is A. You can be sued for an intentional tort. Question 2.5. Which of the following is a basis of negligent tort? A, duty to be careful is owed. B, duty is not met due to negligence. C, harm results. D, causation. E, all of the above. The answer to question 2.5 is E. You owe a duty to be careful. You must check out the area behind any target you are shooting. If you are negligent and fail to check out the area behind a target and harm to someone results, your act caused the harm. You may be considered to have negligent tort liability. If your carelessness is not merely negligence, but is recklessness or wantonness and harm results, you may also be criminally liable. We have discussed the civil liability you might face in your use of force, looking at both intentional and negligent torts. We have also reviewed your duty to report non-receipt of firearms training. Now we are ready to look at the instructor's role in firearms training. As instructors, you carry the same basic liabilities, both civil and criminal, as the students you instruct. You have additional responsibilities by virtue of your role as instructor. First, we'll discuss the criminal liabilities.
Okay.
KRS 237.126 is called misrepresentation of having conducted training courses. If you falsely claim that you have provided training to someone whom in fact you did not train, you can be prosecuted under this statute. If convicted, you would be guilty of a Class D felony. The penalty includes a possible sentence of up to 5 years in prison. For example, you sign off on a form indicating that a relative or friend has completed the training and is qualified for a CCDW license, when you know he did not receive the training, or you don't know if he had training or not, you have committed this offense. KRS 237.128 is called providing incomplete firearms training. If a student begins your course but for whatever reason misses any part of that class, you are not to qualify that person for a CCDW license. Falsely claiming that you put a student through the entire course will subject you to prosecution and, if convicted, subject you to a possible prison term of up to 5 years. Kentucky law requires that certain standards be met to qualify someone to obtain a CCDW license. Any fraud on the part of an instructor regarding these standards may subject that instructor to criminal sanctions. Civil law also imposes duties on the firearms instructor. Instructors owe a duty of care to their students, so obviously you can be held liable in negligence actions if anyone is injured while attending your training. To succeed in a negligence suit, someone must prove that the instructor, 1, had an affirmative duty of care, in other words, maintain a safe line of fire, 2, failed to perform that duty, such as did not check to make sure all students' weapons were made safe before scoring targets. 3, because of the failure to perform the duty, something happened. For example, a student fired a shot. And 4, someone suffered an injury. Instructors may also be sued for an assortment of issues outside of the realm of negligence. For example, instructors may be sued if someone is injured on their property or at the site of the training due to falling on ice or tripping in a hole in the ground. Instructors can also be sued if their helpers cause harm to someone. And of course, you can be sued for your own intentional and negligent acts that cause someone to be hurt, as we have discussed earlier. We have reviewed the issues that you may face as a firearms instructor, including misrepresentation of training provided, providing incomplete training, and various liability claims to which you could be subjected. Hopefully this information will assist you as a firearms instructor.